Hello, welcome to Legalese. My name is Christopher Lilly, I'm your host. Today's topic deals with the right to petition and the Anti-SLAPP Statute. I'm joined today by attorney Alan Hoke from Groton. Alan, welcome.
Chris, thank you very much. It's a pleasure to be here. I've been watching the show, and we're going to try and make this topic as interesting as we can for your viewers.
And it is actually a very interesting topic. We're dealing with, it's referred to as the Anti-SLAPP Statute, and you may not understand what that means just by virtue of the acronym of the letters, but it deals with the very right to petition that's guaranteed by the Constitution, correct?
That is correct.
So what is the right to petition?
The right to petition is one of the fundamental underpinnings of our democracy. And it basically means that people have a right to speak their mind to the organs of government, to the police, to people in the judicial system. They have the right to have their grievances redressed. They have the right to be heard. Many countries in this world, you don't have that right. Mm-hmm. Here in the United States, that is one of the most basic, fundamental rights that we enjoy as citizens. And the right to petition ranks among the upper echelon of rights that we enjoy in our democracy today. It is fundamental to how we live in a free society.
So the Anti-SLAPP Statute, and particularly us being located in Massachusetts, we deal with the Massachusetts statute. What's the number of the?
It's the Massachusetts Anti-SLAPP Statute is embodied in Chapter 231, Section 59H.
59H.
Yes.
And anti-SLAPP, what does that stand for?
Well, we all know what anti means.
Yes.
SLAPP, the acronym SLAPP means Strategic Litigation Against Public Participation. In the 1980s and in the early 1990s, the legislature became aware of instances where developers, let's just say, would file a lawsuit against people who spoke out at planning board hearings or perhaps at a town meeting or maybe at a meeting of the Zoning Board of Appeals. And they would file these lawsuits against citizens not because they wanted to win them, but because they wanted to make the lives miserable for people who were exercising their right to petition the government for redress of grievances. So it was seen that the people filing these lawsuits were doing so as to obtain strategic leverage, to make people invest their time and money and hire lawyers and otherwise defend themselves, to inflict pain and hurt on people who wanted to voice their opinion in front of the organs of government. And
that typically began within the planning board setting?
It could begin at a town meeting for a zoning variance where the town meeting needs to vote on to extend or modify zoning. Mm-hmm. It could happen in front of a planning board where a citizen gets up to speak against a developer who is seeking a special permit or waivers or is trying to build something that he doesn't have a right to do by right with a subdivision or development or a road. There could be something in front of a Zoning Board of Appeals mm-hmm. where somebody is challenging a setback application that a petitioner has filed in front of the ZBA. It could also involve someone who went to a court and obtained a restraining order or a harassment prevention order or a protective order, some kind of order from a judicial officer. There's a wide range of statements that people were making back before this statute came out, and statements that would then get them involved in a lawsuit.
Okay. You see sometimes, people make complaints to the police where they have reports filled out, they make allegations.
Sure.
Is that something that the Anti-SLAPP Statute addresses as well?
Yes.
And what else does it address?
Well, for instance, let's just say that you were being victimized by someone with whom you had a your significant other. Mm-hmm. If that person was threatening you with harm or actually harming you, well, then you would go to court and you would get a a protective order under Chapter 209A, or under other circumstances, you might get a harassment prevention order. You wouldn't be going to a ZBA or a planning board to get that order. You'd be going directly to the district court. That kind of interaction between you and the court is also considered protected petitioning activity.
And you were recently involved in a case dealing with the harassment prevention order. We're going to talk about that in just a few moments.
Okay.
What I'd like to get at is kind of breaking down, if you would, the anti-SLAPP statute and what it is geared toward protecting.
Sure. The Anti-SLAPP Statute was enacted in, I think it was 1994 in Massachusetts. I believe there's about, I did a count this morning in preparation for the show, I think about 20 states have a similar law. And the statute is designed to protect 5 particular kinds of petitioning. And it's lengthy enough so that I want to quote it accurately, so I'm going to read from my notes.
Okay.
A party's exercise of its right to petition shall mean, 1, any written or oral statement made before or submitted to a legislative, executive, or judicial body, or any other governmental proceeding. 2, any written or oral statement made in connection with an issue that is under consideration or review by one of these bodies. 3, a statement that is reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body. 4, any statement reasonably likely to enlist public participation in an effort to effect such consideration. Or 5, and this is the catch-all, any other statement falling within constitutional protection of the right to petition government.
Okay.
So you can see these are very broadly construed categories that were designed to protect a wide variety of protected petitioning activity.
So let's begin with an example. I find that I have been sued because I made statements to the police about somebody, some actions that somebody had done. What are my rights at that point under the Anti-SLAPP statute, and how would I enforce those rights as a person who was sued for my statements, for my petition, so to speak?
All right, well, let's assume in your example you've been sued for malicious prosecution or abusive process, something of that ilk. The first thing, most people would probably elect to have a lawyer represent them, especially because the anti-SLAPP statute is a little bit more involved and requires a significant amount of work to do it right. Under the anti-SLAPP statute, you have 60 days within the time you have been served with a summons and complaint to bring what's called a special motion to dismiss. And even though in the discretion of the court, someone who waits more than 60 days can bring a special motion to dismiss, but like I said, it's within the court's discretion and is not guaranteed. The first 60 days after you've been served with legal papers, that's when you have a right under the anti-SLAPP statute to file what's called a special motion to dismiss. In this motion, you are going to claim the protections of the statute, and you will typically take the position that you are being sued because you have elected to engage in protected petitioning activity.
Okay.
The statute requires that everything that you solely engage in protected activity, in other words, everything that you're accused of doing, which is the basis of the suit against you, has to be protected petitioning activity in order for you to take advantage of the suit. Let me give you an example. If you are accused of engaging in assault and battery and protected petitioning activity, you would not have the right to file a special motion to dismiss because nobody has a right to commit assault and battery. So if what you did was protected petitioning activity in going to the police and filing a police report, You would then point that out in a special motion to dismiss, and typically there would be an affidavit submitted by the moving party, who in this case would be a defendant, and he would point out that why he filed the police report, the facts that caused him to file the police report, that he was engaging in protected petitioning activity,
Right.
and then he would sign that affidavit under the pains and penalties of perjury. His lawyer would then file that motion in the court, at which point the anti-SLAPP statute requires that the motion be heard as expeditiously as possible. And the policy reason behind that is because if someone is being sued on account of engaging in protected petitioning activity, the court wants to know about it, and the court needs to act on that as soon as possible. The other effect that filing a special motion to dismiss has is that discovery is automatically stayed. The frequent listeners to your show probably know what discovery is, but I'll explain it for those who don't.
Good.
Legal discovery is in asking someone to answer questions under oath. Those are called interrogatories. Or asking someone to produce documents that are relevant to the case. That's called a request for production. Or filing a notice of deposition where you obtain oral testimony under oath, or filing other kinds of documents in an attempt to obtain evidence that will be used to support either a claim or a defense at the trial, if there is one. You can ask the judge under the special statute for special permission to engage in some discovery, but the judge is under no obligation to give you what you want.
Okay.
So we start off with the normal situation that once you file that motion, the other side can't get discovery from you. At that point, the other side is obliged to file an opposition to your special motion to dismiss.
What's the burden now at this point?
Well, under the Anti-SLAPP Statute and under the cases that have interpreted the Anti-SLAPP Statute, the burden is first on the petitioner to show, like I said, like we talked about, that what they're accused of doing is all protected petitioning activity. Once they have...
So that's a burden of going forward? Is there a burden of proof there
That's
gets
their
triggered?
burden.
Yep.
That is their burden, to show that what they are accused of doing is constitutes protected petitioning activity.
Okay.
At that point, once the moving party has met their burden to show that they're petitioning, the burden then shifts under the law to the non-moving party.
To do what?
And he has to show or she has to show by a preponderance of the evidence that the petitioning activity is either devoid of any factual basis, or that it has no arguable basis in law, and that the non-moving party has suffered injury as a result of this petitioning.
Okay.
This is a very tough burden to show. The burden is intentionally set high because of the legislature's view that protected petitioning activity is accorded such an exalted status in our society that we don't want to make it easy for people to go against those who have engaged in protected petitioning activity. We like people to petition. We want them to petition. So if you're going to go after somebody for petitioning, the law says you better have a very good case. And that's why the burden is stated in such stark terms.
So to use the example that we brought up of the assault and battery, as the party that is now opposing that that motion of special motion to dismiss, how might you see that?
How might
that defense come up?
Well, let's just say there are numerous defenses that might come into play. The person accused of assault and battery might say, it wasn't me. I wasn't there. I was on vacation in the Caribbean, and here is my Airbnb reservation. Here are pictures of me in the Caribbean. Here's me having a beverage on the veranda of my hotel, and you would get an affidavit from people who were with you, and you would then establish that their complaint has no factual basis because you didn't do it.
So effectively, in that scenario, you made it up.
You made
and
it up.
therefore it's not a legitimate petitioning.
That's right.
Okay.
So if you have a legitimate basis for petitioning the government, whether it's a statement you make in front of any governmental body, or your state rep, or if you testify at a hearing or at town meeting, or a statement made to a judge trying to get an order to protect you, that is typically going to be held to be protected petitioning activity. But if, like you say, you make it up, or you're trying to hurt somebody by bringing a frivolous claim,
Right.
then the law allows the non-moving party to show by a preponderance of the evidence that this petitioning is meritless. It has no basis, and they should not be allowed to continue with that.
So it's a protection against frivolous claims on either side.
In essence.
And you recently had a case go up to the Supreme Judicial Court dealing
did.
with the Anti-SLAPP Statute. And it was dealing with that high burden of being able to oppose a I'm sorry, not a petition, but the special motion for dismissal under the Anti-SLAPP Statute.
That's correct.
Can you tell us something about what you went through?
Well, this was a case where I represented a fellow who was running for selectman. And as part of his campaign, he organized what's called a meet and greet in his town. And that was an opportunity for people who didn't know him to come and talk with him and hear what his views were on the issues and the issues facing the town and what he would do if he were elected. And so a number of people showed up to hear the client talk about what he would do if he were elected. Someone else, a political opponent of his, went to that meeting, and the client alleged that at this meeting, this person made all kinds of interruptions and asked questions at inappropriate times in an overt trying to mess up the client, trying to distract him, trying to disrupt the meeting. And at the end of this meet and greet, there was an exchange, a rather testy exchange between the client and the person, the political opponent who had shown up. And this person, at the end of the exchange, this person is alleged to have said, "You need a restraining order," or words to that effect. This person then went to the police department and filed a police report. And after that, this person went to the district court and obtained what's called a harassment prevention order under Chapter 258E. I don't know if you've had provision to talk about that on one of your shows.
We have spoken about it, I think, when it first came out, and it's only been in existence for
few years.
5 years.
Yeah.
And it deals with, it kind of expands the abuse prevention orders that deal with families. It expands it to really any kind of interaction between peoples, and you see it a lot with neighbors. But in your case, what was the situation?
Well, in this case, the complainant went to the district court and said that she had been the victim of multiple threats to her safety and well-being, and she was heard by a district court judge. She was on, that hearing was recorded, and the judge heard the complainant make her case, and the judge issued a harassment prevention order under 258E.
Right.
What the law requires is 3 separate instances of statements or conduct that is intended to incite fear or harm, and which does in fact incite fear or physical harm. So in my case, the judge issued that order, and it was served on my client. He was then not allowed to approach her or go near her, and that affected his campaign because she was involved in town affairs and so was he, and there was a political campaign going on. So he basically couldn't go anywhere. He couldn't do anything to further his campaign because of fear he would run into her.
Sure.
A few days later, this person went back and got a modification to the restraining order.
Now, it was originally issued ex parte without your client being present, correct?
That's correct.
And the second the time that she went back, was that also ex parte?
Yes,
Really?
that was ex parte as well.
And all right, so at what point do you become involved?
Well, I became involved shortly after that second hearing.
And I'm sorry, how was it amended on the second hearing?
The second judge amended the original harassment prevention order to include an order that my client could not mention or discuss this person, couldn't mention her name, couldn't talk about her in a blog or a tweet or an email. In other words, even though this person was a public official, my client couldn't say anything about her. That was a huge problem.
Mm-hmm.
Under the Harassment Prevention Statute, 258E, the judge holds a hearing 2 weeks after the order is issued to see whether it should be extended.
Mm-hmm.
And in this case, the client obtained the services of counsel, not me, to represent him at this hearing. And so 2 weeks after the order was issued, the original order was issued, there was an evidentiary hearing. The judge heard from the complainant. The judge heard from my client's side, and the judge terminated the order. The judge found correctly that this was basically political speech.
Right.
And that political speech is enshrined in our Constitution. You have a right to make political speech. So the judge dismissed the order. Shortly after that, I was retained by the client, and we brought claims for abusive process and malicious prosecution against this person. Shortly after the papers were served, the defendant obtained the services of counsel and filed a special motion to dismiss.
So you're now at the defending stage of this anti-SLAPP special motion.
That's right.
And you now have to deal with this very heavy burden that we just discussed.
That's right.
And what happened?
All the alarm bells go off at that point. Now you've got to move quickly because, as I said, the judge needs to hold this hearing expeditiously. So one of the things we did was we went to the police station and obtained the police report. And there was some very damaging evidence in that police report as to the state of mind of the person who had obtained the harassment prevention order. Evidence that would lead one to conclude that this person really didn't feel fear and that the person had an ulterior motive for going to the candidate's meet and greet. And as it turned out, one of the things that my client did was he had a sign-up sheet at his meet and greet. And so those people signed up and we had their names and addresses.
Right.
Well, we contacted them immediately. And as it turned out, we found two people who had never met my client before. They didn't know him from Adam, but they saw he was running for office, and they wanted to know a little bit about what his platform was, what he stood for.
Right.
So they went to the meet and greet, and they saw this exchange, and they saw how this person was conducting herself, and they filed, they signed affidavits to the effect.
These are affidavits that you created.
They were affidavits that we created based on what they told us. Because I wasn't there. I didn't know what they said.
Right.
I didn't know what they heard or
Sure.
what they saw. They did. So they told us what happened, and we included that in our package. We collected other evidence in the form of an affidavit from the client and submitted our opposition papers.
Okay.
The judge, unfortunately, ruled against us. And when someone brings a motion under the Anti-SLAPP Statute, they're entitled to an award of attorney's fees. That is a very powerful tool in the Anti-SLAPP Statute.
Sure.
So we appealed the judge's decision to the appellate division of the district court, and in an appellate opinion issued by that court, we won.
Right.
The court found that this was not legitimate petitioning because the harassment prevention statute had not been complied with. The other side.
That didn't end the case, though.
We thought that was going to end the case, and maybe sometimes it would. In this instance, it did not end the case. The other side then filed an appeal with the Massachusetts Appeals Court.
Okay.
And when the Supreme Judicial Court got wind of that appeal, they transferred the case to the Supreme Judicial Court on their own motion. As the highest court in the land, the Supreme Judicial Court has the power to do that.
Right.
So they heard the case, and they issued a decision. And they basically said, look, the harassment prevention statute is pretty clear. You've got to have 3 separate instances of conduct or actions that are designed, as we talked about, to inflict fear or harm, and which do in fact inflict fear or harm. Mm-hmm. This is political speech. There's no 3 instances of conduct. It's political speech. Political speech is enshrined in the federal and state constitutions, and therefore she did not meet her burden.
Okay.
Now, in the burden-shifting provisions of the Anti-SLAPP Statute, it was our job to show what the court decided. That is, that her petitioning had no basis in fact or law, mm-hmm. and that the client suffered damages. The client did in fact suffer damages because he was required to retain counsel to represent him at the hearing to determine whether the order would be extended.
So the damages was the amount that he had to pay his attorney.
Yes.
To defend against the original harassment prevention order.
Precisely.
And not the attorney's fees for all of the appeals that came up afterwards.
No. And so the SJC, that was a very helpful decision, mm-hmm. and the SJC determined there were a couple of technical aspects to its decision concerning the manner in which appeals are handled, because there was some question before this case, mm-hmm. about how that would happen. They answered that question, but it was most helpful for the court to acknowledge the right of people to petition, but also to point out that the harassment prevention statute cannot be used inappropriately, mm-hmm. as a tool to stifle someone from expressing their political views.
Can't be a sword, it's a shield.
Exactly.
Right.
That's exactly right.
And we're dealing with, as I said at the beginning of the program, we're dealing with the right to petition, which is guaranteed by the Constitution of the United States as well as the Massachusetts Constitution. And Alan, I want to thank you for speaking with us here today about our right to petition and how those rights are protected by the Anti-SLAPP Statute in the Commonwealth of Massachusetts. I want to thank you all for paying attention. Anything you hear here today, I would ask that you not consider as legal advice, but talk to local counsel such as Alan. Alan, where can you be reached?
You can find me at alanhoklaw.com. I have an office in Groton. I specialize in litigation, wide variety of litigation. It's almost exclusively a litigation-based practice where I work as a trial lawyer. Mm-hmm. And I have a particular interest in this kind of work. It's very interesting. It gets multidisciplinary very quick. Yeah. And you end up meeting a lot of nice people and working the cases.
Thank you, Alan.
Thank you very much.
Thank you all.
Thank you.